Now, the book is really impressive because it really addresses all the dilemmas, assumptions, procedural and legal issues that have permeated the first years of the existence of the court, and brings new light to all problems and tensions. Already the first chapters set the tone and bring us back to the basics. Why is international criminal justice important? And here I think it's a very interesting chapter because it really is observed in this chapter how the proponents and supporters of international criminal justice have left behind some rationales of innocence and guilt of perpetrators of serious crimes, and have put an emphasis on other objectives, such as a contribution to peace, contribution to conflict resolution, to contribution to the consolidation of democracy, contribution to stability. And this is, as well is observed, has also put the focus on obtaining some other results. So justice is not anymore defended or argued because what can achieve on itself, because it is important as a moral or duty obligation to ensure the criminal responsibility of perpetrators, but as an instrument for other purposes. And this, as it's clearly put, is also has shifted the focus on something that is based on principles of moral obligations to something that is based on achieving results. And this, of course, can be also a backfire, and of course has also put the emphasis in trying to see whether these results are indeed achieved through international criminal justice. And here we see also in the book some chapters trying to see whether indeed in the first 10 years of the court and also of other, in the experience of other tribunals, whether, for instance, international criminal justice has had a deterrent effect, whether it has indeed had a useful impact on peace. Peace by saying no more violence. And there is an empiric analysis of some of the experiences of the court in Uganda, DRC, etc. And of course, the evidence is scant, as one of the contributors says, is anecdotal. It is very difficult, as we all know, to prove the negative, which basically is to prove that thanks to international criminal justice, something has not occurred. Whether there is or not a deterrent effect of justice in the immediate, mid, or long term is yet to be seen. But of course, the negative, the positive impact, I would say, is difficult to assess, but also there has been, and throughout 10 years of this court, a lot of arguing about the negative impact that justice can have in, for instance, in peace negotiations. So this has been a dilemma and a tension that has been also a part of the first 10 years of the court, and before that of the other tribunals as well. And of course, is extremely a very important discussion that is going to be continued because the court has moved, the International Criminal Court has moved squarely into the ongoing conflicts. So this tension of peace and justice becomes more and more important, and there is no real answer to this. Now, these issues of the effects that can have the court on peace and justice and on other elements of international relations is also related to these dilemmas that are encountered for the selection of situation and cases. And the book also addresses this, which is a hugely important, probably the most important and more difficult question that the ICC has to respond. where to investigate, who to prosecute. And there is a critical analysis of what has been done. There are chapters describing how this is done. And of course, also all the difficulties that the court, as a permanent court, has in deciding where to move, when to move, and how to move forward. We all have seen that in the last 10 years, all these trigger mechanisms that we included in the Rome Treaty, from the Security Council referrals, proprio motu, none of them has provided easy answers or magic solutions to this very thorny question. So this is it's important to analyze, it's important to see how it was done, and why certain things had some adverse effects, or at least in terms of perception. But of course, there are no easy answers to this, and we will continue to struggle with this. And of course, there is these contributions in the book about the importance, in any event, to avoid any perception of double standards or biased justice, something that is very difficult to avoid, in particular when you have a treaty body which has treaty limitations to the jurisdictional reach and no universal participation in the treaty. So many questions that cannot be answered, many contributions to continue this debate. And since we cannot really say what is the effect for other purposes in the mid or long term, it is yet difficult to say for sure that the court will have a deterrent effect, for instance. Then what do we do? You have already said something that is said in the book, is first of all, some modesty is welcome. And indeed, some of these grandiose statements that were characteristic of the early days when we needed to establish a court now could be tempered by some realism and a healthy dose of skepticism, which is very good for the debate. So we don't say things based on faith or ideology, but things that are based on facts and that can and probably are better for the cause of defending the role of justice. But in addition to modesty, what else can we improve? Well, whatever the effect is in the mid or long term, and we all hope that it will have a beneficial effect, is that in any event, we need to improve the performance of the court. And again, the book makes a good contribution in this effect because it takes stock of 10 years of very rich practice and analyzes the problems we've had in terms of procedure, in terms of substantive law, in relation with complementarity. And I do note your chapter, for instance, where you say that maybe we are too Hague-centered. That maybe while we are saying that the primary responsibility remains with states, we have established a model that basically makes of the investigations and cases at the court as the role model for the cases that need to be investigated and prosecuted at the national level. I think this type, and this is based on a jurisprudence that, of course, is yet to, probably the start of something that will continue in the second decade on issues of complementarity and how to assess cases at the national level and international level. And then there is all these chapters on the criminal proceedings, on the relation between pretrial, trial, etc. And you, as you all know, we are now embarked with my colleagues, and several of them are here, trying to see how we can improve or how can we expedite our proceedings, how we can identify the best practices of the first 10 years, how we can agree and harmonize what can be indeed be harmonized for the second decade, so we don't reinvent the wheel at every step of the road, but really try to apply this very complicated procedural and substantive legal framework in a way that is helpful for more expeditious trials. So this book is a good contribution for this purpose, for an exercise that we are doing inside the court, and to contribute to a debate that in many, many respects is only the beginning of the debate and probably will continue, and you don't need to wait for 10 more years to write the second one, because you will see so many decisions and activity in the coming months that you will have a lot of food for thought earlier than that.